this search warrant was illegal and that the information received from Google should be suppressed and all evidence collected by law enforcement thereafter is fruit of the poisonous tree and should also be suppressed.
All right, court is calling 2023 CR 10854, State of Texas versus Bradley Galvan. Can I have parties announced for the record for the state?
Andrew Harris,
Defense.
Orlando Castañón for defense.
All right, and you're Bradley Galvan?
Yes, ma'am.
All right, so my understanding, and hopefully this will be corrected today, that the name that should be in the indictment is Bradley Galan. Is that correct?
Yes.
That
All right,
is,
so how do you spell your last name?
Galan.
All right, so that needs to be corrected in the indictment. Let me look at the indictment and see if it's spelled as Galvan. In the indictment, it's spelled Galvan, so the indictments need to be corrected. Is there going to be an objection if the state decides to amend the indictment to include the correct spelling of the last name?
no, Judge.
All right, state, that needs to be done.
Yes, Your Honor.
All right, so now we're here on a motion to suppress and cause number 2023 CR 10854. It's the court's understanding that the court's ruling on this case, if I were to grant it, of course, then it will have repercussions as it relates to 2024 CR 0339. But for purposes of your motion to suppress, it's in regards to 2023 CR 10854. Is that correct?
Yes, Judge.
All right, defense, it is your motion. Do you have any witnesses?
No, Judge. We have provided the court with the copies of the affidavits for search. And I believe the state doesn't have any objections to that.
Correct, Your Honor.
All right, and then state, do you have any evidence you wish to present?
One bit of information to proffer to the court. Warrant affidavits generated by Warden Burkett. The warden specifies 6 longitude and latitude coordinates to limit the geographic area of the geofence request. The courts can use those location coordinates to determine the geographic area, but it would be easier for me to relay to you that Burkett already did that calculation and knows what it is.
All right, so are you offering into evidence those calculations or
Yes, sir.
the map?
As long as defense has no objection.
I believe the map is actually in the arrest warrant. I mean, the affidavit for search. But I have no objections as to the extent of the square footage.
Considering that Burkett informed me that the approximate area of the search location is 0.22 square miles.
All right, and you're in agreement that that is the length?
That is the total area, Your Honor.
All right.
Not the length or the width of both combined.
All right, and are you in agreement with that being the total area, counsel?
Judge, I do not know for fact if that is the square footage. I have no objections as to if that's what they're proclaiming it to be. I don't believe that that is what is at issue in this case. And so I have no objections if that's the square footage they're representing it to be.
All right, so state, do you have the actual photo of the area from Google Maps or someplace or no?
Yes, Your Honor, it is contained in the warrant application.
And I believe in the first warrant application, there is a geographical location with a map in it.
All right, so you all are offering that into evidence?
Yes, Judge.
Yes, Your Honor.
All right, so just make sure that is marked. And how is that going to be marked?
Be Defense Exhibit 1, if you like, Judge.
All right, Defense Exhibit 1, just make sure there's a printout for the court reporter.
Yes, Judge.
So Defense Exhibit number 1 is, for the record?
It is going to be the application for warrant. That is CM 088445.
Could you repeat the CM number, please?
Yes, Judge. It's CM 088445.
All right, so that will be Defense Exhibit number 1. Any other exhibits?
No, Your Honor. Or at least not from the state.
There are other warrants that were requested In regards to the geofence warrant itself, the warrant that is really a question is that CM number we just spoke of, but there are three other warrants that were filed or requested. There's three applications, and I can read those off. They relate to once the geofence warrants were granted and executed, they received information, and then the search became more narrow. But without the first warrant, they would not have been able to receive any of the information and would not have been able to apply for any further warrants.
All right, so your sole motion to suppress is based upon defense exhibit number 1?
It is, Judge, but I think just for the record, to be clear that we would also move to admit those other warrants as well.
All right.
And I have those numbers.
So defense exhibit number 1, and what is defense exhibit number 2?
That would be CM 097930.
And what is that exhibit?
That would be a search warrant, the application for search and a search warrant dated from April 1st, 2022.
All right, any objections to that state?
No, Your Honor.
All right, and then what is the next defense exhibit?
Yes, Judge. And then on May 5th, another application for search
Oh, everyone, please whisper.
was applied for and granted on May 5th, and that CM number is CM 098757.
And will that be defense exhibit number 3?
Yes, Judge.
All right. And then is there a defense exhibit number 4?
There is, I don't believe I actually listed that number in my, but I can pull that out.
What you've sent to the court in the email with the state included in an email, you have a 4th and 5th warrant as well?
There is a 4th warrant for search, and that's going to be related to the one we just spoke about was the residence. The 4th warrant would be the actually, I'm sorry, there's 5 warrants in total.
Mhm.
The 4th warrant was for a cell phone. That CM number is, we just spoke of, was a CM number 098757.
All right, so defense exhibit number 4 is the search warrant for a cell phone, correct?
Yes, Judge.
All
There
right.
was the affidavit for search, that would be the 3rd exhibit. And I don't know if I've got these out of order, which it sounds like I did, is a CM 098707.
098707,
Correct.
and that search warrant is related to what?
The residence.
All right, so defense exhibit number 1, that's the application for the warrant, correct?
Yes, Judge. For the
Defense
geofence warrant.
for the geo, okay. Defense exhibit number 2, that's a search warrant, correct?
It is, and that is for specific information regarding to my client's user information from Google.
Okay, so that's user info. And then defense exhibit number 3, what search warrant is that for?
That is for the that itself was for the, it looks like that was actually I thought it was the residence. They were. Yes, sir.
Might be a little bit easier if you borrowed my laptop.
All right, thank you. I just want the record to be clear what each item is. So let's start. Defense exhibit number 1 for CM 088445. That's the application for the geo warrant, correct?
Correct.
Defense exhibit number 2, which is CM 097930. That's the search warrant for his user information, correct?
That is correct.
Okay, defense exhibit number 3, that is also CM 097930. Is that correct or no?
That's 098707.
All right, 09807.
Yes, Judge.
That's defense exhibit number 3.
Yes, Judge.
And what is that exhibit?
That is,
Because I believe, off the record for a moment, I
Yeah.
believe you said that was the residence. Because I have defense exhibit number 3 as CM 098757.
yeah, that's just for the residents.
All right, so we're back on the record. So defense exhibit number 3, is that 098757?
That is 098707 for the residents.
All right, CM number 098707, which is defense exhibit number 3, is for the residents. And then defense exhibit number 4,
That is 098757. And that is for a cell phone.
that's the cell phone. And then defense exhibit number 5,
I believe that is to unlock the cell phone. Let me verify that.
Mhm.
Yeah, that's the information for his cell phone.
and that's the same CM number.
Yeah, that's going to be CM 100259.
All right. So defense exhibit number 1, it's the application for the geo search, correct?
Correct.
Defense exhibit number 2 is the search for your client's specific user information.
Correct.
Defense exhibit number 3 is for the search of the residence.
Yes, Judge.
Defense exhibit number 4 is, I guess, the seizing of the cell phone,
Yes, Judge. That was not at the residence, it was on his person.
okay, on his person. And defense exhibit number 5 is the warrant to unlock the cell phone and collect data.
Correct.
All right, so those are the 5 exhibits from the defense?
Yes, Judge.
All right, and then state, do you have any exhibits?
No, Your Honor.
All right, and if you all will make sure that those exhibits are printed out to be included in the record for the court reporter. And then with that being done, I will hear argument.
Yes, Judge.
Defense?
So, Judge, in regards to Mr. Galan, game wardens were called out on January 14, 2021 to investigate a scene where they found some dead animals or dead deer. And in part of their investigation, game wardens then sought search warrant in Exhibit 1. They sought to seek a geofence warrant, which gathers information within a specific location within a specific time. And so that warrant itself does not list any specific person. It is a dragnet. There's a 3-step process in regards to getting more information to find the specific user that they believe would be the suspect in that case. It's unsupervised. So when they did receive the warrant, they filed that request on April 26th. They were then given some information. They narrowed that information down to a smaller group. And then from there, there's a second step that Google law enforcement request systems requires, that they then narrow down their search request. They then give that information to Google. That is not supervised by a magistrate or any judge at all. They simply provide that information without any supervision. Google then responds to that. It will give them subsequently more information that is narrowed. And then the third step, they then review that information and then they determine as to who they believe that specific person is. After step 3, they then determined that they believe that Mr. Galan was the suspect in that case, and then they issued a a second warrant, which is defense exhibit number 2. That warrant is for the user information on Mr. Galan, where they then gathered more information that they are using to allege then to receive a search of the residence where Mr. Galan was living. That was exhibit 3 in that search warrant. Then during that time, they searched Mr. Galan's house, where they believe they found contraband. And in doing so, they then ended up getting a search warrant for his phone, which was on his person, and then subsequently a search warrant for to unlock the phone and gather that information. Now, that's the background of the facts of that case. The geofence warrant itself, though, is a dragnet. They do not ask or request information based upon a specific person. So there are innocent parties that they will end up receiving information that's personal and private. And so, you know, that information is of innocent people. And so the Fourth Amendment prevents the government from, you know, seeking information, being able to go into a person's private effects. And a person has a right to be secure in their person, their house, papers, effects against unreasonable searches and seizures. And so they need a warrant. The government needs a warrant in order to enter into anybody's personal effects, their house, residence, and such. And that has to be based upon probable cause. Now, the Fourth Amendment provides that no warrant shall issue without probable cause, and that the government has to particularize the place to be searched and the person or things to be searched, and that the Fourth Amendment requires a warrant to be supported by probable cause, that it describe the place to be searched and the things to be seized, and be issued by a neutral, disinterested magistrate. And if a warrant is invalid, the proper remedy in the criminal action is ordinarily to suppress the evidence derived from it. And so that's under United States v. Thomas. The probable cause demands that the law enforcement possess a reasonable grounds for a belief of guilt, particularized with respect to the person to be searched or seized. That's under Maryland v. Pringle. The Court of Criminal Appeals, Texas Court of Criminal Appeals, has found that the Fourth Amendment prohibits law enforcement of gathering warrants that are lacking in specificity, that the police may seemingly engage in general exploratory rummaging in a person's belongings. That's Walthall v. State. That's 594 Southwest 2nd 74. More recently,
Sorry, could you spell that name for the court
yes,
reporter?
Walthall is WALTHALL v. State. Now, and more recently, the United States Fifth Circuit in United States v. Smith, that's 23-60321, has held that these geofence warrants are actually general warrants. And they found that general warrants are not, and it has been longstanding law that general warrants are not constitutional. They articulated that these warrants are fishing expeditions occurring while law enforcement officials have no idea who they are looking for or whether their search will even turn up a result. So similarly, in Mr. Galan's case, Texas game wardens did not know who they were looking for, nor did they know if their dragnet search would turn up any results. In requesting the geofence warrant, game wardens sought location information for all Google account owners who entered the geofence over the span of 36 hours. The warrant on its face swept in unrestricted location data for private citizens who had no reason to incur legal scrutiny. It's been recognized that a warrant cannot be obtained to search everything or everyone in sight. A warrant to search all persons present for evidence of a crime may only be obtained when there is a reason to believe that those present will be participants in a suspected criminal activity. And that's in the Owens v. Lot 372 South Federal 3rd 267. That's out of the Fourth Circuit Federal Court. That all persons, warrants can pass constitutional muster of the affidavit of information provided to the magistrate, supply enough detailed information to establish probable cause to believe that all persons on the premises at the time of the search are involved in criminal activity. So the geofence warrant issued in April 26th of 2021 was used to gather Google user information on at least 72 people that had nothing to do with this specific alleged criminal activity. Then without supervision of a neutral magistrate or a second request under the same geofence warrant was made to Google to produce data of a narrow subset of 13 users. That data was then used for a third request under the same geofence warrant, again without a magistrate's supervision, to request data from Mr. Galan. Law enforcement then filed an affidavit search using information gathered from the original geofence warrant to obtain a second search warrant on November 16, 2021 to obtain Mr. Galan's Google account information. And then again on May 5th, they went into his residence with a search warrant. May 6th, they executed a search of that house and obtained a warrant for his phone and also again for the information in there. And as such, geofence warrants are general warrants and not supported by particularized probable cause. Therefore, I will note that in US v. Smith, in the Fifth Circuit opinion, they found that the warrants were general. They did state in that opinion, though, that they did not suppress the evidence based on a federal rule of good faith, which is different than the state rule for good faith. And the Texas Texas rule with code criminal procedures is
38.23B.
yes, 38.23B. And that it says a warrant, there's a good faith exception when a neutral magistrate signs on that warrant based on probable cause. And probable cause exists only when it is not based on a general warrant. So we'd ask that this geofence warrant be denied as or be seen as inadmissible, and that it's an illegal search, and therefore all the subsequent warrants should be not admitted as well as evidence, and the evidence in Mr. Galan's case should be suppressed.
All right. State.
May I proceed, Your Honor?
Yes.
As a threshold issue, a request for location history data is not a search. To understand why we need to examine Carpenter, reasonable expectation of privacy that the court in that case elaborated, and how it is distinguishable from location history data. In Carpenter, the court considered two lines of cases. The first line addressed a person's reasonable expectation of privacy in their physical location and movements. That line of cases included U.S. v. Knotts and U.S. v. Jones. In Knotts, the court held that visual surveillance augmented by a beeper hidden in a container did not constitute a search because the movement of a vehicle had been voluntarily conveyed to the public at large. In Jones, the court held that a GPS tracker installed on a vehicle constituted trespass. However, 5 justices concluded that longer-term GPS monitoring in investigations of most offenses impinges on expectations of privacy, regardless of whether those movements were disclosed to the public. The second line of cases discuss the third-party doctrine, which asserts that a person lacks a legitimate expectation of privacy and information voluntarily disclosed to third parties, and traces back to U.S. v. Miller. In Miller, the court ruled that a person does not have a reasonable expectation of privacy in bank records, since they are records of the bank over which the defendant cannot assert ownership. Similarly, in U.S. v. Smith, the court ruled that a pen register was not a search because a person who places a call voluntarily discloses the number he dials to the phone company. In Carpenter, the court analyzed cell site location information regarding these two lines of cases and concluded that people have a reasonable expectation of privacy in CSLI, cell site location information. The court reasoned that mapping a person's cell phone location over the course of a prolonged period of time provides an all-encompassing record of the person's location, considering that people tend to take their phones with them everywhere they go. Moreover, CSLI is collected without any affirmative act on the part of the user beyond powering the device. Finally, because cell phones have become, in the court's estimation, a ubiquitous and necessary aspect of modern life, it is not reasonable for a person to sacrifice having one in order to avoid being tracked. Because of their pervasiveness, the passive way in which they collect information, and the exhaustive and detailed amount of information they provide about the user, the court found that CSLI is distinguishable from a pen register or bank records such that disclosure to a third party does not negate the reasonable expectation of privacy. However, the court went on to say that its conclusion was a narrow one, and it declined to express a view of other forms of electronic data collection, such as real-time CSLI, tower dumps, or other business records that might reveal location information. Which brings us now to location history data, which is distinguishable from CSLI in several ways. First, whereas CSLI is collected passively, a Google user must opt in to location data tracking. Moreover, even if a person has opted in, they can subsequently opt out if they choose and can review, edit, or delete the collected information and stop Google from collecting more. Thus, a Google user must affirmatively consent to the collection and storage of location data and can revoke that consent and delete the information if they so desire. Moreover, whereas cell phones are ubiquitous and necessary, location data tracking is neither. As far as ubiquity is concerned, the U.S. Fourth Court of Appeals noted in U.S. v. Chatry that 2/3 of Google users do not have location history enabled. As far as necessity is concerned, a person can still use Google products even if location history is not enabled. Activating location history might arguably make a Google product work better, but one can still use the product while opting out of location tracking. Because of these distinctions, location history data is more akin to the bank records and pen registers of Miller and Smith, respectively, for which a person lacks a reasonable expectation of privacy, and as a result, the disclosure of that information does not constitute a search. But let's say, for the sake of argument, that you are unconvinced and believe that location history data collected from a geofence request is a search that requires a warrant. The question then becomes whether that warrant was supported by probable cause and particularly describe the place to be searched and the thing to be seized. First, a warrant is supported by probable cause if, under the totality of the circumstances set forth in the affidavit to the magistrate, there is a fair probability that contraband or evidence of a crime will be found in a particular place at the time the warrant is issued. It is important to remember that probable cause is a flexible standard that does not require certainty, it only requires probability. The Texas Court of Criminal Appeals in Foreman v. State has stated that it is not even a 50% rule. A fair probability will suffice. Moreover, the probable cause standard accommodates searches that may not turn up evidence and that may invade the privacy of the innocent. See Brinegar v. U.S., Illinois v. Gates, U.S., and Zurcher v. Stanford Daily. So in this case, Sergeant Game Warden True observed a deer that appeared to have been killed by an arrow. True followed the trail of blood left by that deer and using his training and experience, which had not at this point been called into question, concluded that the deer had been shot at approximately the location where the blood trail began, which was a public right-of-way. True also determined, through his training and experience, that the deer had been killed within the past few days. Based on this information conveyed to Warden Burkett, Warden Burkett requested an evidentiary warrant which did not require probable cause to believe a particular person committed the offense. It only needed probable cause to believe that Google had relevant data that would provide evidence of the offense. Burkett did this by articulating the observations made by True, by describing Google's location history, feature, and storage policies, and noting that since the suspected location was used by other, presumably non-hunting people, potential unknown witnesses to the crime might be located. Second, the warrant sufficiently described the place to be searched and the thing to be seized. Since the warrant did not authorize search or seizure of a person, no description of a person was necessary. Under Bonds v. State, a warrant is sufficiently particular if it enables an officer to locate the property and distinguish it from other places in the community. Moreover, a court may look to extrinsic facts in determining whether the language in the warrant is sufficiently particular. In this instance, the place to be searched was Google's records for its electronic consumer data pertaining to location histories, limited by the particularities of the geofenced area and relevant time frame. Similarly, the warrant particularly identified the thing to be seized. In this instance, the the thing to be seized is the data itself, which is likewise limited by the specified geofenced area in the relevant time frame. Now, defense counsel cites to the Fifth Circuit's decision in US v. Smith, particularly the circuit court's claim that such warrants are fishing expeditions occurring while law enforcement officials have no idea who they were looking for or whether the search will even turn up the results. Well, with all due respect to the author of that opinion, they fundamentally misunderstand the purpose of search warrants and the probable cause standard. Once again, the probable cause standard for a search warrant does not require law enforcement officials to have some idea of who they are looking for. It doesn't even require them to have an identifiable suspect. See Dominic v. State. Similarly, it does not require them to know that a search will in fact reveal evidence. The probable cause standard only requires a law enforcement officer to demonstrate to a neutral magistrate that there is a fair probability that a search of a particular place will reveal evidence of an offense. But there is a much bigger problem with the Fifth Circuit's reasoning in Smith, because that court held that all geofence warrants, no matter their particularity, are general warrants because the data set is so vast. This seems difficult to reconcile with the Supreme Court's holding in US v. Carroll, in which the court explained how to draft a warrant for the installation of a location tracker in physical space. The court wrote, "It will still be possible to describe the object into which the beeper is to be placed, the circumstances that led the agents to wish to install the beeper, and the length of time for which beeper surveillance is requested. In our view, this information will suffice to permit issuance of a warrant authorizing beeper installation and surveillance." The warrant problem in Caro is similar to the warrant problem in Smith, which is similar to the warrant problem here. The place to be searched is basically everywhere the location tracker could conceivably go on the face of the planet. But the court found a way by specifying the place to be searched as the object into which the location tracker would be placed, the particularity being satisfied by the amount of time of surveillance. Moreover, Smith is difficult to reconcile with Carpenter itself. After all, in Carpenter, the court opted for a rule that warrants are necessary to search CSLI. But CSLI and location history data do share one thing in common. They are essentially stored in huge databases. If this court adopts the Fifth Circuit's reasoning, then this court endorses a rule that a warrant is sufficient, except when the database is massive, which amounts to a rejection of Carpenter itself. But let's say, for the sake of argument, that you are still unconvinced. In that case, 3823B still does not require the suppression of evidence. As the Court of Criminal Appeals noted in McClintock, an officer who reasonably believes that the information he submitted in a probable cause affidavit was legally obtained has no reason to believe that the resulting warrant was tainted. In executing the warrant, that officer acts in objective good faith reliance upon the warrant as long as the warrant is facially valid. Thus understood, the language of Article 38.23B is consistent with the application of good faith principles to excuse a prior illegality and thus renders an officer's reliance on a neutral magistrate's assessment of probable cause objectively reasonable. Accordingly, we hold that the good faith exception of Article 3823B will apply when the prior law enforcement conduct that uncovered evidence in the affidavit for the warrant was close enough to the line of validity. As an aside, I love that phrase. That an objectively reasonable officer preparing the affidavit for executing the warrant would believe that the information supporting the warrant was not tainted by unconstitutional conduct. In other words, and to sum up, if an officer acts in objective good faith reliance, presents evidence to a neutral magistrate, the neutral magistrate determines that there is probable cause and issues the search warrant, then the evidence collected as a result of the warrant should still be admissible, even if the neutral magistrate's determined probable cause was retroactively determined to be incorrect. So, for two reasons, you should deny the motion. It's not a search. The geofence warrant is not a dragnet. For a third reason, even if you choose to uphold the motion, the evidence collected as a result of that search warrant should still be ruled admissible.
All right. Any response?
Yes, Judge, two things. One, in the cases he cited, and especially in Carpenter, there's a difference in those cases. They actually knew of the suspect they were seeking to get information on. In this particular case, they didn't know whether they were even going to receive any information. It was a guess that they might receive information within this geographical location. And so in Mr. Gallan's case, they did a dragnet. They just asked for everybody's information within a specific time and this specific place. When he speaks of Carpenter, that case deals with an individual who was an accomplice in a robbery. That information was received from an individual who had been arrested and gave information regarding Carpenter's participation. And so they actually knew and were able to particularize who the warrant was for and what information they were seeking. In this particular case, Mr. Gallan's case, that is not what they did. They did do a dragnet. They sought any and everybody's information without even knowing whether they would find any information, whether they would find any data. It was a guess. And secondly, the state is positioned that the federal good faith exception applies in Texas, and it does not. In the federal good faith exception is based upon not whether the warrant itself was based on probable cause, but whether it would prevent law enforcement from seeking these illegal warrants in the future. And so the standard he's trying to assert applies in Texas, it does not. And because of that, we ask that you grant this motion to suppress.
Okay. And it's the court's understanding that this is an issue that is being taken up in the appellate courts?
It is being taken up by the Court of Criminal Appeals here in Texas, and as well, and I could provide you with a brief, and I can provide the state with that brief and the.
Oh, I've read it.
Okay.
Okay.
And as well, because there's, I think, a division in the federal courts, the Supreme Court may also be taking up this issue.
All right. So this is what the court is going to do. I'm going to reset this matter. I've heard both parties' arguments. I'm going to reset it for December 19th. It appears to the court that economically it would do no good for this court to make a ruling on it if the appellate courts decide something different. So we'll have to wait and see what the appellate court's ruling is, because they are an authority that's higher than this court, as is the Texas Supreme Court and the United States Supreme Court if it goes there. So we're going to see where they are on December 19th. Sometimes it takes a while for them to issue their opinion. So is there any objection to either side to the court resetting this for December 19th? And I'm saying this, of course, for purposes of speedy trial issues.
Yes, Judge, I don't have any objection to that.
All right, so this will come back on December 19th, and we'll see where the appellate courts are at on this situation. And on that time, state, if you can make sure that if there are any changes to the indictment with regards to names, if that could be taken care of as well. All right, thank you.
Thank you, Judge.
Thank you, Your Honor.
You're welcome. All right, Medina. All righty. Let's bring him up.
Here, the preview, Judge, it's going to be a plea of truth, an explanation, and no read recommendation.
All right, I love previews. It's like the trailer, right?
The problem with the previews is I tend to go through all the topics. I have nothing left for the movie.
But you know, I always try to be there for the previews, because if the movie is horrible, you can say, well, I can look forward to these other movies. I remember Mom took us to see a movie, and it was Clash of the Titans, the one with Harry Hamlin.
Oh, the graphics are horrible, but it was a great movie.
No, at the time the graphics were great.
What?
And let me just tell you, that guy who did that, his graphics are still great, because Sinbad, the sailor, all of those graphics are still great.
Great Harryhausen.
Yes, but when we were there, you know what, when we were waiting for Clash of the Titans, you know what the preview was? Raiders of the Lost Ark.
Oh,
And so my mom would take us to the movies probably like once every 2 or 3 weeks. But that was the time she said, we're coming back the next Saturday and we're seeing Raiders of the Lost Ark. But it was great. Those were the days. All right, court is calling 2023 CR 3508, State versus Marco Antonio Calendres. Could I have parties announced for the record for the state?
Andrew Harris, Salem.
Carl Alexander for Mr. Colindres.
And are you Mr. Calendres?
Yes, Your Honor.
All right, did you review the document entitled Motion to Revoke Community Supervision and First Amendment to Motion to Revoke Community Supervision with your attorney?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Are you the same Marco Antonio Calendres who was placed on community supervision in 2023 CR 3508 for the offense of driving while intoxicated third or more on August 24, 2023 for a term of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Heard about the tenth day of December twenty twenty-three in Bear County, Texas. The defendant, Marco Antonio Colindres, did then and there consume alcohol in violation of condition number 2.
All right, how do you plead to that? True or not true?
True.
State waives the remaining violation allegations. Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, sentence you to 4 years in the prison and a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. What are you requesting, state?
Revoke supervision, assess the underlying sentence of 4 years.
And defense, what are you requesting?
Judge, we're asking that you deny the motion, that you continue him on supervision. And my client is asking for help. So in our discussions, and part of what I was doing during court is reaching out and seeing if it's even possible. He is a veteran. He continues to struggle with some unresolved PTSD issues and obviously substance abuse as well. I spoke with the state earlier this morning and this afternoon, kind of looking into his criminal history. It is a true DWI third. My client does acknowledge that he does have an alcohol problem. You will see, I'm sure, on the First Amendment motion, there was a new number 1 out of Travis County. That case, per my client, has been rejected or dismissed.
And what is that case about?
Apparently when picking, may I, am I allowed to tell her? Okay. So in executing the court's warrant for the MTR, he decided that he was going to flee initially when he and his cousin were stopped, which is really an evading. It's still a new number 1. I get that, but it's alleged as an escape. My understanding is Travis County has declined to go forward on that. Mr. Garahan did a TCIC, NCIC over the lunch break. There's no prosecution available, so I have no reason to disbelieve my client about the resolution of that case at this point. Mr. Colindres was going through some financial troubles, Judge, because I was trying to ask some of the questions I figured you'd probably want to know.
Well, this is what I want to know, because I'm not the one who placed him on probation. Another judge placed him on probation. So probation on Calendres. Has he ever had any treatment? Because what I see the other judge wrote, well, all he wrote was 2-year, I think it was Judge Harrell, all he wrote was 4 years probation, $1,500 fine, 2-year license suspension, 10 days in the Bear County Jail, GPS, TAP, 150 hours community service restitution. That's it. So has he received any treatment? All right, so this is what the court will do. The court, you have a choice. I can't give everybody choices. Here's your choice. 1, we can refer him. You're saying that he's a veteran?
Yes, Judge, he's per him, and he does have his DD 214 available. His mother would have to provide it because he's in custody.
Well, have you seen it?
I've not seen it, Judge. I have no
Do you
reason.
know 100% that he's a veteran?
I only know what he's represented to me, Judge.
Does anybody have the report? Was there a PSI done? Are you saying you're a veteran?
Yes, Your Honor.
What branch?
United States Air Force.
Just 1 second. Do you know if Veterans Treatment Court, can you call somebody from there to see if they can at least see if he was in the military? Yes, if you can ask him to come down. All right, just have a seat. All right, sir, if you'll come down. John, thanks for running down.
course, Judge.
All right, so on this case, he's never had treatment before. It's obvious that he needs treatment. I didn't take his plea, so I wasn't unaware. I didn't know he was military, so I wasn't aware of that. Defense is saying that he says he's military. He's saying he's military. Of course, as you know, we need proof that you're military. So how long would it take?
So we were speaking, Your Honor. I can say the conversation we had, he couldn't have held with me if he didn't serve. So he did give me his reentry code. Unfortunately, you okay if I share it? Fortunately, he can't ever rejoin the military.
Okay.
He did have a few different issues that we kind of talked about. He reports he doesn't have any of his paperwork. So I was speaking with the attorney and him, it's the fact of I can make a call, and it was also the finding point of you can call and confirm whether someone is or isn't. So now's the time to tell me. The problem is going to rely on the fact of I will run with it pretty quickly as far as I can go. We have set up an opportunity to where right now there is a Zoom possibility that we can have between the three of us or even his mom. His mom is here in town. If we get him registered on My Healthy Vet, because right now he has not touched the VA system.
Okay.
If we get him registered there, we can expedite it to where we can get the paperwork that we need. However, we'll know tomorrow if he's telling what he's saying is true. And I'll start the eval process as fast as we can, push him through for felony VTC. When we get to the staffing table, which can happen every Thursday, we have docket. I'm trying to think of logistically here. Probably within 2 to 3 weeks, we can have him at the staffing table. The state of Texas, part of the DA's office, is that we're gonna have to show something. If I can show that he's registered, it's approved, the fact that we've confirmed it through military records that he served, what he's telling me, other than honorable, the reentry code, security forces for about, I apologize, about a year and 6 months, and unfortunately got chaptered out. We can work with that. And then we can ultimately, when the VA, you know how the government works, Your Honor, sometimes it takes a little longer for them to print out a paper and hand it to them. Once we get that, we'll just add it to his file. So it's really just how fast we can get him registered with the VA, which we can do as quick as we can get him on a Zoom call.
All right, so here's my question. So is that something that can be done while he is in custody or no?
Which part? The registration part
Well,
or the eval part? The
The
evaluation
eval.
part? Yes, we can run right now. I have given him my business card. If you choose to take the route of signing the referral, Your Honor, I will give him the instructions of what to mail me. He can do it while he's in his, unfortunately in his cell, he can write it out, he can send it to me. It's really at the point of registering is whether or not his defense attorney and himself are willing to set up a Zoom call for us to get in, which right now I'm assuming we can do. He's
Yeah.
on board with.
I'm willing to do it, but the requirements the jail has on doing that, the soonest they'll be able to do it would be Monday.
Correct,
you have
yeah,
to
so
do
then we're
24
working with the
hours.
jail requirements, Your Honor. So yes, I'm on board to do it. If that's the route the court would like to choose, we'll work within the parameters that we
all
have.
right, do y'all want to have him brought over on Monday? Would that make it easier for things to be accomplished or no?
What the thing we would need to do would be registering him, like, well, it's a computer system.
So if you're the.
I mean,
yeah.
theoretically, like, let's take my
Theoretically.
calendar. I could sit in here with my laptop on the defense Wi-Fi, sit in the box with them,
Okay, if that's easier for everybody to do, it can be done that way.
or, actually, Judge, I have court tomorrow. I'll be in the courthouse tomorrow morning. If it's not too late,
Mhm.
sorry, guys, if it's not too late to order him for tomorrow, just for the purpose of me able to sit down in the box with him and do the registration.
We could request an original promises, cause it's after
Yeah, I know.
3:30.
Yeah. I
So,
know.
all right, they'll request him and we'll see what
So fingers
happens.
crossed.
Yes.
I'll bring my laptop just in case.
All right, it is Marco Calandras. So we can go back on the record. We're back on the record in 2023 CR 3508, State versus Marco Antonio Calandras. Court has found violation of condition number 2 true. The court will deny the motion because it appears that you have not been given treatment. Court will alter the main conditions to include a referral to the VTC. If he's not accepted in the VTC, then there'll be a referral to felony drug court. And he's to remain in custody until transferred to VTC or FTC. Is there anything else?
No, Your Honor, thank you.
Stay.
All right, is there anything else you need?
No, Your Honor, thank you.
Herman, is there anything else?
Good, Your Honor, I'll keep you updated.
All right, thank you. Thank you.
Thank you, Judge.
All right,
No be excused.
yes.
See.
Bashan,
Okay.
on Saturday, Bashan, I will be here.
You'll be here.
Yes, there are some students who are coming over on Saturday to view the courtroom. So I will be here. Yes, do you want to come in on Saturday? Deputy Laura, Deputy Mahia, can y'all have somebody brought over for Saturday since I'm gonna be here anyway?
Of course not, Judge.
Yeah.
Do people know that you're bringing this class since they have to be screened before coming in?
Yes, they do know.
Okay.
So Judge Ramon used to always threaten, if we didn't finish this trial, then we're gonna come in on a Saturday when I was her prosecutor. And she delivered on it one time.
Oh, yes.
This one, E3 and Tochi